I have newly engaged, my lord, on Monday, my lord, last Monday, my lord. I need 1 week time, my lord.
11 is the 19 matter.
Lordship, 1 week time, my lord. Next week.
Okay, on Monday next.
Oh, Lordship.
On Sri A. Mubarak, learned counsel for the petitioner has informed that he has been newly engaged and has accordingly paid for some accommodation para. Considering that this matter is pending since the year 2019, while a short accommodation is granted, comma, the matter is directed to be listed on 17/8
What?
for admission hearing.
What?
May to mention item number 17.
17.
17.
Yes,
It is a 29 pattern.
yes.
In this case, on account of my son, there is not. I need some accommodation. Even I am not in a position.
Why?
We are- After 10 days,
No, why are you seeking time?
because we not, I could not.
Sorry.
Hello.
You are at your own risk. If you do not prepare a case of 19, we are not going to accommodate. Sorry.
At least 1 week time.
Sorry.
May I please?
No adjournment. No
Item
adjournment.
4, Your Lordship, item 4. It
4, yes.
became infectious,
4 has become infructuous.
Lordship.
Why?
As per full bench judgment dated 25/4/24, it has become infectious because it is a transfer
Okay.
for prayer for transfer, Your Lordship.
Okay. We have decided.
Already decided.
Yes. Sri P. Rahman, learned counsel for the petitioner, has submitted that in view of the judgment dated
25/4/24.
25/4/24, passed by a full bench of this court, comma, the matter has become infructuous. Full stop. Also heard Miss A. Verma, learned standing counsel Home and NRC. Asabar naam likhe diba. The matter is accordingly closed as infructuous. Yes.
Record may be sent.
Records be sent back forthwith. 17.
17, my friend, mentioned.
Hello.
Copy of the writ petition may be served.
Give a copy. Yes.
Wait, please, Your Lordship. Lordship, in item 3 and item number 30, yesterday we have circulated at adjournment.
We have
petition.
seen, but why are you seeking adjournment?
Your Lordship, here the arguing counsel is not available. She is out of station.
19 matter. Okay. On a request made on behalf of Ms. D. Ghosh, learned counsel for the petitioner, matter is adjourned to be listed on Monday next.
Lordship. Deeply obliged.
May please the Lordship.
Lordship, can it be on 18, Your Lordship?
Tuesday.
Yeah. Deeply
On
obliged.
18th. Separate, huh?
Yes,
3N,
Your Lordship.
3N,
3 and 30, Your Lordship.
13,
Yes.
1, 3, 30.
30 and 3.
3N, 30. Okay. Do it separate orders.
May please the Lordship. I wish to mention item number 19 on behalf of the engaged counsel, my lord. He is out of station due to demise of his family member. He is coming today. Perhaps in second half, he will reach the court.
Okay, a prayer for adjournment has been made on behalf of Sri A. Hussain, who is stated to have suffered some bereavement para. Matter is accordingly adjourned to be listed for admission hearing on 19th of August. 19/8.
May please, Your Lordship. Lordship, I back to mention item number 20, Lordship. The
Okay.
last occasion notice was issued, Lordship. Lordship, what happened in this matter, Lordship? The petitioner, I am unable to connect with him, Lordship. Now
Not a good
No,
enough
Lordship,
reason.
some other advocate engaged me, Lordship. Just one accommodation, Lordship.
Let
I will
them come.
connect it.
If some other
Lordship, on
advocate is there,
next week, no,
sorry,
next week, Lordship.
that's not going to work out in this.
They may engage some other
Let them.
advocate, Lordship.
Why are you bothered with them if they are not?
I need to inform
sorry.
them.
19 matter, don't make this kind of prayers and requests. Sorry,
May please. I wish to mention item number 15.
1-5.
Yes.
Yes.
If you're shifting of our chamber, we are not able to trace out our office copy since 1 week time,
When did you shift chamber?
last month.
Last month. Not a good enough reason.
1 week time.
Sorry,
We
let
have
it.
no office copy.
Sorry, let it reach.
We have no
Maybe.
office copy.
Hmm?
We have no office copy. That's why
You have to.
we have no office copy. That's
We
why.
do not know. That's not a good enough reason. Sorry.
May I please, Your Lordship?
19 matter, no adjournment.
Yes.
May I please, Your Lordship? This is item number 25, admission. Lordship, my seniors today not available before this honorable court.
25.
25.
Yes, what is your prayer?
Sir, I am affair on behalf of my senior. Lordship, my senior is not available before this honorable court today. So kindly adjournment this order for 2
Matter of which year? 25. Okay. Records have come. So we'll have it on Wednesday next. Okay. On a request made on behalf of Sri S. Hawk Learned Counsel for the petitioner, matter is adjourned to be listed on 19th of 19/8.
I have blessed me.
I beg to mention for item number 16.
16,
due to
yes.
Personal difficulty of my senior counsel, matter may adjourn for the day.
What personal difficulty? He is in the court. Sorry.
Does it come up?
He's in the court or not?
Yes.
So this is a more important matter of 2019. Sorry. Sorry. Those will not do. Will not work out here. Sorry. Yes.
May I please, Lordship? Lordship, I beg to mention item number 7, 8, 9, 10, and 35, 36, and 37, Your Lordship. APSC matter, Your Lordship.
APSC matter before any other bench.
Yes,
Huh?
Your Lordship. Your
Please before any other
Yes.
bench. Without one of us bracket me. 7 to
7, 8, 9, 10, and 35, 36, and 37, Your Lordship.
Wompala 35, 36, 37. Okay.
Plus, sir.
Item number 5, yes. We have the new matters first, then we'll have the old matters. Item number 5, H. Bhuya M.R.Z. Chaudhary. Who are the counsel?
The 2019 opinion lordship. Court had called for the report, I think CCRA say.
Already come.
Then this 26 matter,
But the opinion is of 2019 lordship.
that is okay. We can issue notice and have it for admission hearing, but in absence of the counsel.
2019 opinion.
None appears for the, okay, let's wait for a while because there are 2 items above this. If he might think that, yes, you are the counsel. Which one? No, not you, not your case. After a while. Six, yes, madam.
Lordship, my senior counsel lacks on another courtroom.
Who is your counsel?
Mr. M.I. Hussain.
Ask him to come. What is the matter?
It's a 2026 opinion. We
We can issue notice. Are you there on record, madam? Are you there on record?
You're in the case. You're not in the case.
Yes, yes.
Yeah, you're in the.
What is your name?
My name is Arkha.
Arkha.
You're there.
We can issue notice. Heard, Miss Arkha. What is the case about? What are you challenging?
15/6.
Order, Lordship, impugned order.
Impugned order, obviously impugned order will be challenged. Of which, who has passed the order? What is the consequence of the order?
Learned Foreigners Tribunal, Bongaigaon.
What is the consequence of the order? What has been ordered?
Lordship.
What has been ordered? Just a minute, let her answer. She is on record. She should know the facts.
In 6/26.
Lordship, here I am declared foreigner.
You have been declared a foreigner.
Yes.
Which stream?
1971, post stream 1971.
Under what law?
Foreigners Act, Section 9 of Foreigners.
You should know the facts, madam, at least facts. Basic facts.
25/3/1971. That is the cutoff date under Section 9 of the Foreigners Act, 1946.
Okay. Heard 3 M.I. Hussain, learned counsel for the petitioner who has put to challenge an opinion dated 15/6/2026 passed by the learned, which tribunal? Learned Foreigners Tribunal, Bongaigaon number 2,
Yes.
Obhaipuri, in FT case number so and so, whereby the petitioner has been declared a foreigner post 1971. What are your grounds?
Lordship, the learned tribunal has declared only on the basis of some contradictions in name, Lordship. That is mentioned, Lordship, may kindly see.
The learned counsel has submitted
Name contradiction.
Yes,
that
Lordship.
only on some trivial issues pertaining to contradiction, inconsistencies in name, comma, the impugned opinion has been passed. Full stop, para. That notice be issued. Returnable on 12th, no? Returnable on 21st of September. Union of India. Will be appear for Union of India. Okay. Your CGC. CGC. Okay. So for CGC for Union of India. And madam for 2,
Lordship, 4, 6 and 7.
2, 4, 6 and 7 A Verma. 3 Election Commission of India S Kotoki, Standing Council ECI for 3. District Commissioner Mr. P Sharma, State Council. Okay. Extra copies, that's a call for the records. So and so, praise for an interim order. What is the date of the opinion?
Lordship, 15/6/2020.
Okay. Okay, you appear before SP border
Lordship.
on or before, today is 12th, on or before 21st of August. Okay. And 20,000, huh?
Deeply obliged, Lordship.
Yes, 5.
Lordship, I'm appearing behalf of 8 Fuya. He is out of session, Lordship.
He is out of station. Okay, we issue notice and we put it.
We can issue notice.
Sure.
What is your name?
S. Burman.
S. Vermont.
Burman.
Heard Miss S. Vermont, Learned Counsel appearing on instruction of MDH Bhuya for the petitioner. Para. In this case, comma, this court wide order dated 1/6/2026 had called for the records pursuant to which the records have been received. Full stop. The challenge is against an order, an opinion dated. What is the date of the opinion?
23/5/2019.
23/5/2019, passed in so and so, so and so, whereby the petitioner has been declared a foreigner post 1971. Para. Let notice be issued, returnable on same date, huh? Must be issued 21st of September 2026.
19 opinion.
Okay. Union of India, okay, same, huh? Same Union of India. 1, and then State of Assam, madam. 2, 4, 2, 4, 6, and 7. Election Commission of India S Kotoki 3, and Deputy Governor 5 whole P Sharma. Let extra copies be served. The Learned Counsel for the respondents have, however, raised an objection on the maintainability of the writ petition on the ground of delay. Full stop. The aforesaid issue is accordingly left open. Then do it. Taste the recording. 23rd, both the matters. 21st is a holiday. 23rd, madam. You give extra copies. Board extra copies लिखी दी वहाँ.
42 substitution.
May I please over? My lord, in this case, I am on behalf of Mr. H.R. Choudhury. My name is not on record. My lord, it is a very strange case, my lord. The learned tribunal.
Strange case. Why?
Already-
What is so strange about it?
My lord, already he was declared Indian, my lord. And the learned tribunal sumoto reopened the matter, my lord, and declared him foreigner, my lord. Sumoto reopened, my lord.
Is it permissible, madam?
My lord, kindly see page 29, my lord.
Madam Verma, is it permissible? Suomoto, is it permissible? Where is the impugned opinion?
Earlier order, my lord, page 29, my
No,
lord.
no, present.
Present, my lord.
There was no reference. What do you mean by so much on its own?
Instructions, next week, Lordship.
And my lord, petitioner is in detention camp, my lord. His detention is quite illegal, my lord. My lord, learned tribunal must have,
When were you taken into detention?
my lord, on 4/6/2026, my lord.
4/6/26.
26, my lord.
You take instructions Monday.
Store out, so we'll.
Or we can issue a short notice. Short notice, because he is raising a very pertinent point. If the powers are not there, then the subsequent opinion and detention will also go. But if you can trace the power, because review power is there, whether review power can be exercised, so moto. That is one question which will arise. And what is the ground? What is the, not the ground, what is the basis of initiating the suo moto proceeding? Let us see the impugned order. Page.
Actually, suo moto review would be something like recall almost. Suo moto power, exercise of power of review would be something like recall. Recall.
Yes, my lord.
Sometime
And there is
exact
no
on the
review
480.
petition, my
Which
lord.
page?
Page, my lord.
By the apex court.
Page 46, my lord.
Impugned order.
Impugned order.
46.
Present order, my lord.
46. Let us see the initiation. How is it done? How did the learned tribunal proceed?
There is no whisper about the earlier opinion, my lord. And same case, same reference, my lord.
Same reference.
Same reference, my lord. Had it been a different reference, my lord, situation would have been otherwise, my lord.
It's not a suo moto.
My lord,
Your case is different. You have not put your case in the proper perspective. You say that there was an earlier opinion.
yes, my lord.
Ignoring that, another opinion has been passed.
Yes, my lord.
It's not a suo moto. Suo moto would amount to recalling the earlier order,
My lord.
passing a fresh order.
My lord, my case is that learned tribunal must have gone through the records, my lord.
No,
before it
that is what you think. We do not know. There is no reference to the earlier order,
Yes, my
opinion.
lord. And kindly see the reference number, case number
Did he
of,
place before the tribunal that he was declared Indian?
in the very similar case, very same
But
case,
did
my
you
lord.
pass
Oh.
that first order?
No, my lord, that
The
is not.
reference is the same.
Same, my
reference
lord.
is the same.
Reference, same case number,
That
same,
means
my lord.
in the same reference, two judgments were given.
Yes, my
Is
lord.
it the?
This is my case, my lord.
No, but Mr. Chaudhary, in this case, while you had contested, did you apprise the tribunal?
No, my lord, that is one part, but my case is that, my lord, when the learned tribunal himself issued notice in the same case, my lord, he must have been aware about the earlier opinion. my lord.
That is not an answer.
But I have to tell.
That is not the answer. You are the aggrieved person. The first moment you receive notice, you say you cannot
First thing,
proceed.
I've already.
I have
been
already
declared
declared.
No, my lord, had
Indian
it
by
been a
you.
different,
The same for
different
tribunal.
case, had it been a different reference, my lord, the situation would have been other, that I have been declared Indian in another reference, my lord.
No. This case, your burden is much more.
No, my
You
lord,
cannot even proceed.
He contested in this matter.
my lord, my
Very
lord,
surprising.
that part will come later, my lord. How learned tribunal issued notice when there was an.
Mr. Chaudhary, you are hesitating this in the High Court. Why didn't you point it out in the tribunal?
No, but that is.
You let everything have happen,
that is-
opinion
that is-
come, put
That
it to
is-
challenge, then you suddenly,
He is an illiterate, that is another, that is lapse on the part of the petitioner, my lord.
he had filed written statement. Where
Yes.
did you take the issue?
No, that,
Then
First issue, it has to.
how do you find fault with the tribunal?
no, my lord, there is a fault, my lord, because before issuance of notice, my
No,
lord.
no,
Liner
it's
type-
not that simple. Let us see the earlier order.
Yes, my lord. Same notice, page 29, my lord. Type copy, page 28.
614. Page 29. Six one four, same. 50 case number. 480. Very short order.
Some judgment was passed by the High Court on a number of matters where cryptic orders were passed. Is it a part of that?
If
Probably.
reasoning order not appreciated, the tribunal will
Okay.
take it up again. There is.
No, tribunal cannot so moto take. Order may be bad, void ab initio, but it has to be declared void ab initio by a higher court. I think there's something else.
Some facts which my friend is not placing before this court, lordship may call for the records. and-
I will issue notice.
And my lord, my humble petitioner is detention camp, my lord. And prima facie, his illegal, detention is illegal, my lord.
We do not know. We'll issue notice.
He's a
at this.
foreigner, so it cannot be illegal at all.
No, my lord, when there is,
So you did not place that. before
You
the
are not,
tribunal.
madam, this side, not that side.
The cryptic, there was a series of, as my senior brother said, there was a series of cryptic orders which were remanded back. Perhaps might have been one of them.
Maybe one of
Might
them.
have.
You take the instructions.
Examined by the Home and Political.
Most probably.
Mr. Chaudhary, you are not on record.
no, my
Heard Sri
It may be.
AHMR.
Yes.
Chaudhary, learned counsel appearing on instruction of Sri HRA Chaudhary,
Yes, sir.
learned senior counsel for the petitioner, who has put to challenge an order dated 23/20/26 passed by the Learned Foreigners Tribunal 1, Mongoldui, in FT case number so and so, whereby the petitioner has been declared a foreigner post 1971. Full stop. The petitioner, the Learned Counsel, has primarily urged that there was an earlier opinion dated 26/10/2006 in the same reference case whereby the petitioner was declared to be an Indian citizen, and therefore the impugned opinion is ex facie not sustainable in law. Full stop. Para. Miss A. Verma, the learned standing counsel, has however objected to the petition by submitting that the aforesaid fact, if correct, should have been pointed out to the learned tribunal, which admittedly was not done. Full stop. She also seeks time to obtain detailed instructions regarding the matter. Para. Let notice be issued, returnable on, we give a returnable date, we'll consider his interim prayer. Today is 12, returnable on 7th of September. Can you get before 7th? 7th of September, 2026. Union of India. Okay, huh? Union of India. Number 1. Then Madam for A. Verma for 2, 4, and 6. 2, 4, and 6. Okay, 2, 4, and 6. Then District Commissioner P. Sharma and Election Commission number 5. S. Kotoki, Standing Counsel. Huh? Extra copies. Call for the record secondary. Sri Chaudhary, the Learned Counsel, submits that the petitioner is in detention camp and prays for an interim order. Full stop. Para. The aforesaid interim order would be considered on the returnable date based on the instructions. If what he's projecting is correct, then he'll be entitled to an interim order. Okay.
Series of those orders. Series.
Palito, no? Mr. Alim, your matter.
Yes, my lord.
Today we completed. Yesterday we are almost completed, but wanted to give some more consideration.
Lordship, as per your lordship's verbal direction, I searched what the particular covering matter I did not find.
Which one?
That a judge cannot decide in a pre-judged manner,
Influenced.
influenced, my lord.
There would be. Decision-making process has to be done with an open mind.
Yes, my lord. Otherwise,
Now-
it will be natural violation of natural justice.
There would be. Because not only in the first paragraph, in paragraph 6 also,
Yes, my lord.
a first paragraph discarding that certificate to be a forced one, that is a different finding of fact.
My lord.
In paragraph 6, he expresses his mind that you are taking recourse to fraudulent documents.
Yes, my lord.
So that is a general kind of
He
a.
generalized it.
So
That
once
was
it is there, whether
problematic.
it will culminate in a fair decision. That is what we were trying to have from you.
Otherwise, my lord, if your lordship discards the land document and other documents, I have document of 60, 66, 70, 77, my lord. These three documents directly connect me with my parents, and my parents' citizenship are directly proved, my lord.
No, your first voter list is of 1977, correct?
My name is appearing
Yes,
in
your voter list.
my voter.
And you say that in that voter list of 77, there is one A. Hakim and Ujala Khatun. And these two persons are also there in 1970
Yes,
and
madam.
1966.
Yes, my lord.
So you want to contend that a link has been established
Established, my lord.
with Ujala and A. Hakim or
A.
Abdul Hakim.
Hakim.
Now we want to be, and we have to, he has to ensure that these were different persons. If these are the same person, then your link is established.
Yeah, Hakim and Hakiman. And of course, in your case, only one instance it is, the name is different.
Yes, my
Omar
lord.
Bepari and Omar.
I have only submitted lordship.
No, you have just started. You had placed Aziz Mia.
Yes, lordship.
Mere reflection of name in the voters list is not enough. What is the citation?
Lordship citation was 2023 for GLT. Oh, not for GLT. For GLT lordship.
2023 for GLT.
Please check.
246. 2023 for GLT 246. And lordship,
Which paragraph?
para 14 lordship. Yes. I am reading lordship para 14. We are constrained to observe that mere claim by a suspected person by referring to a voter's list claiming a person daring to be his father is not a conclusive proof, and that by doing so the person has discharged the burden that he is not a foreigner. This is because there is also a further requirement to prove that the person who is reflected in the voter's list relied upon is actually the father of the person who makes the claim. The claim will have to be substantiated with further material substantiated acceptable in law. So lordship, here in this case, lordship, apart from
Authorized lordship, there is nothing to link with her projected father. No document has been placed or proved lordship. Although document was placed before the tribunal lordship, it was not proved at all. And Gabra, although deposed before the tribunal lordship.
But Mr. Sharma, it is not a case of one isolated voters list. There are a series of voters list. Aziz Mia, the context in which these observations were made is different.
But,
See, when you say that oral evidence is not admissible, we need documentary. Then he comes up with the voter list, then you say voter list is not enough. And what else? There has to be some. Now, one isolated voter list, his names appear suddenly and gone. That by itself will not ensure that or establish that he is a citizen. He is trying to show a link with two persons who were in the Indian soil prior to the cutoff date. On that context, we are examining. It is not that I have a name in a voter list, so I am an Indian citizen. Inclusion in voter list will mean nothing. I can get my name included by any means. That will not confer citizenship. In that context, Aziz Mia was said. Now here, he is trying to build up a case that there are voters list prior to 1971 having names of certain persons whom he claims to be his parents. And to establish that, he has shown a later voters list where his name appears along with those persons. On that, we want your response.
The issue is the name discrepancy actually. That is the problem. That is the only concern.
Yes, lordship. And lordship, same thing has been said by Khan also. 2002 for SCC 346, 2002 for SCC 346,
2002,
2002 for SCC 346,
name?
BHAN WARWO, Khan or Waru.
BHANWAR Anwaru Khan.
Yes, lordship, and others. Versus Union of India and others.
Paragraph?
Paragraph 15, lordship.
We have not come across this. What is this decision?
Lordship.
We have not come across this. What is this decision, Dharmaru?
Same thing has been said, lordship, long stay in the country and enrollment in the voters list would not confer any right on an alien to continue to stay in
No,
the
that is what we have
Yes,
just said. Mere inclusion will not prove citizenship. But here is not a case of inclusion. And he's claiming because he's there in the voters list.
There things good, lordship. Only one aspect is remaining, lordship. The petitioner has to prove that, lordship, Abdul Khalege, his father's name, lordship.
Abdul Hakim.
Hakim Ali, Abdul Hakim, or Hakim are same and one person. That the procedure has to prove that these persons are same and one person. Lordship, I think, lordship, apart from this, here is nothing, lordship. And Umar Ali and Umar Ali Vepari, lordship Umar, these name discrepancies are there. And apart from that, lordship, here is nothing, lordship. Lordship, I leave it to your lordship.
Have you stated, Mr. Alim, that A. Hakim, Abdul Hakim, Hakim Ali is the same person?
Yes, my lord.
Huh?
I have taken.
Said, not said.
The fittings are there.
Things are there.
Yes, my lord. And furthermore, in this said particular point, no cross-examination was done, my lord.
Anything, Mr. Alim, from your side?
I leave it your lordship's wisdom.
Okay, so. Yes, please. Give. Yes, Salim, then you write the G Sharma, then write everyone, huh? And Kalita on behalf of AI Ali, then P Sharma State Council, and CGC, okay? We'll reserve for judgment. Hearing is concluded, judgment is reserved.
Deeply obliged, my lord.
Well, can it be taken after some time, my lord? The senior will appear, RLE will appear. Lordship.
Imperial order Millard that is annexed to page 18. And imperial order that is Millard 3 on 2012. Fine. My lord.
কাগজ
And now Millard about 64. Now. And those are not. accurate. 62 around. My lord. My lord. Now he is about 60. Actually, it is an expert Millard, only WS I file, my lord. Only when WS file Millard, therefore he could not appear as because there he could not collect relevant documents. And as when the documents collected Millard, in the middle or only WS. Blank. Yes. Thereafter 11 dates passed. 11 dates. Actually, it is not expert also not there. He appear, he know that there is a case. He appeared once. 11 date passed, my lord. 11 days he could not appear, my lord. About 1 year, 2 months. Then the London member may not pass the order. And he came to know all this, my lord, from this local Gauhati that there is a case, police is searching you. Then my lord, he came, collected copies, etc. Then we'll file this case, my lord. Before the honorable court. So he only my lord filed his statement and nothing more. No evidence, my lord, nothing. My lord, yes, 19. Now, my lord, bail has been granted by the honorable court, my lord, on 12/5/2020. By this one. No, not by your, probably not, probably, I have not mentioned your name, but probably Honorable Justice will not, Didan will not. No, this, my. Base will not kindly see 12/5/20.
Last date of listing. Yeah. Just sorry.
No, he was not first. Outside. And till the time here, we are outside. Now he is at about 65 years. So. And Milord, as because I could not file me any documents, I could not prove my case, Milord. My prayer, a chance, sorry, Milord. A chance may kindly be given, Milord, so that I can appear. And as per decision of the Milord, Honorable. Not to me, Milord, frankly speaking, there is no sufficient documents. To me also, I am feeling, Milord, I cannot submit blindly. As because Milord 66, 70, father, mother, okay. And then Milord, it comes to 87, shifting. Then Milord 85, his name appeared, but name was wrong. Milord, his name appeared. That is Milord Savitri, yes, Milord. I have my learning friend. No, actually, file was there, Milord. I started like misplaced name. I misspelled. So, next party, yes. There are the three categories.
If we go by category wise, he comes under category 3 lordship.
Yes, midway.
And chose not to appear. Yes.
Third category. Okay.
Category
There are three
lordship.
categories.
Left midway of the tribunal proceedings. The category 3 is headed like this: appellant left midway of the tribunal proceedings. Not appear. Second is evidence appreciation by the High Court. Second category is evidence appreciation by the High Court. Yes. I have just one objection, lordship. So 2012 orders, lordship allows this. We have so many others. Everyone will start relying on this lordship. And another thing, it is not that he has not appeared at all. If we go by the opinion also,
Is outside.
yes,
And
and in 20. Lordship also has a point. It is there in Savitri Day, it's your last one final opportunity. Savitri Day's conclusion is that only. This remand is not to be understood as
Yes,
approval of the
condoning the conduct.
of the appellants in defaulting before the tribunal. It is granted only as one final opportunity.
Now, my lord, earlier I was, my lord, never, like, now 65, my lord, there is nothing.
He's 64.
Wants to, my lord, should be minimize, my lord, at least, as because nothing is
Very
in
fair, sir.
65 years, my lord, I am.
What do you do?
Now, there is, earlier also, my lord, should confirm that age is 65 years. And at the age of 65 years, my lord, I don't know how he will, my lord. Anyway, after taking bail, my lord, now, yes, forever I am. And the 20, and his phone
6
number
years.
may also,
The lordship.
and his phone number is also not there, my lord. So I am to
6 years
issue a
back.
letter.
6 years back.
Whether a remand order is to do at all, we have to take exercise.
And whether the person is alive.
That is part of the we can say.
And in between, well, I heard. Earlier it will be effective.
Not
It might be SCC online.
copy.
Only, my lord, sorry, I
Can be
might.
neutral site.
Different, no?
Only one.
2026 in SC
It is 2026
and
IN
SC.
694. 694. It's Savitri Day.
No, SA
SABITRI.
Savitri Day alias.
Elias Swasti Day. SWASTHI.
Savitri, they.
Yes.
13th of December.
Also Union of India Lordship, there are about 15-16 matters together. Yes.
13/7/26. 13/7/26.
We have heard extension. This put by order it.
12/5/20.
I don't 5/5/36 and work for the records and then also. The response and after the review. Proceed. Council has something. After receipt of this. From the level and find within states. However, thereafter, there has become miscommunication. And no further steps, including the aspect of finding of the miscommunication. The matter was according to the level That this court, while the above referred order is 25 has not been raised. And there is that by kind of initial judgment of your next people in the case of some equity versus and 694 from this. Prevailing council has applicated that significant justice. Where nothing like that. To give another opinion. To contest the reference. This will not be better. Any from as how we submit that we and that's it on the part of the commission. Stand manifested by that was delay. Both in referring delay in it was done after almost 7 months from the day of and also highlight that it is not a case that the petitioner was not aware of the proceeding in the direction and has not yet clear and find within state, whereas he had not been at his own information. Here the court certificate that the petitioner cannot be entitled to any equitable from this court. The process for rest of the standards has moved its admission advanced by the government and has raised the discussion of the institution for the plan. Appearance of the court and of the hearing to participate in the fund that can you receive this from the government and also however, there is nothing in the top of food that if in a guide would be not necessary. I will not be predicting this. Asking this to the on 3 1. We do not find any form in the as all proceedings are required to be completed within our time frame as provided in 314 order 3 or order 3 within the next 14 of the ordinance order 1962. We have also seen that the fact that after finding the mistake and therefore we were last of the petition and the section 9 of the census was at the same time the justice and observe at a fair opportunity is required to be basic opportunity where we our hard citizens need doubt. Consider the balance we are defending that justice is served The date for appearance and filing of all the evidence of the country. Filing petition in support of its case. That such will be fixed on 12, on 14th of September. On the 9th of September, and of September. On such appearance, you can find of evidence of faith. How was the position? What is the position of the problem? You don't have to. Third of the sentence and proceed with the back. You have to most steps for expeditious. Is going to be in terms of order. The of order of that if the petitioner not divided by the commission of the things and evidence and evidence probably fixed for the then remain. The 200. So you become victim. Then becomes then can be report. Item number. 10. 12. Ulema Katul. Expert.
No, man, contested.
How the receiver goes. Chris. They do Chris. So. Hearing approval. No false. Tap on my. Text 7,
39. Terminal number first, Morigaon. First. Test 39.
Sulema Kapoor.
Yes, my lord. My lord. My lord, a file in 26/10/18. 26/10/2000.
How many witnesses?
2 witnesses.
2 DWs. One is you. DW one is petitioner and the other one,
Another is brother.
brother.
Yes, sir.
Let us see the documents.
The documents, my lord, started from page 45.
40.
5. The school service certificate, my lord, it is exhibit A.
48.
45.
45.
Exhibit A.
Shansheri.
My lord.
Sonsheri.
Sonsiri village.
Sonsheri.
Sonsiri.
Emi Vidyapith.
My lord.
You have the original of this, madam?
My lord.
Check the records. Please have the records.
It was not proved, lordship. The school certificate was not proved.
Not proved.
Not proved.
You had produced that
Yes.
petitioner. They are not proved by the school authorities.
English material. Hardware certificate not proved, school certificate not proved, lordship. And I'm making it easier for him.
Easier or tougher for him?
He said I'm going direct to the point. I said I'm making it easier for you.
She point out
No,
correct.
Mr. Ahmed will have something in his sleeve. He'll not disclose now. Gradually he'll disclose. Gradually he'll disclose.
He make it difficult for me, lordship.
No. Today I just asked my sister to, he's rightly pointed out.
Now, what was troubling in this? Good is not proved.
My
See
lord.
the dates and the see the signature and the dates. Headmaster signs on 17/4. The counter signature by the block elementary is on the same date, 17/4.
My lord.
It may be possible, but it will raise some doubt.
It has been
You know, it is
Yeah, that we have seen.
Yes.
That she left the school in 1992
92.
and certificate is dated 18. 18 plus 6, 24 years.
It may be, it can be obtained, but the question is not proved.
This is
Not,
the,
yes,
but it can be
it
obtained.
can be obtained.
And then
Correct.
BO also put counter signature.
Mm.
No, there is no doubt about the genuineness of this certificate. But only but if now only option
The Gambura not proved.
not prove only.
Page 47,
Let's put this
Exhibit B,
exhibit B.
date 31/5/18. Thereafter,
So these two are the vital documents. So which can prove the
Linkage.
linkage. That document has not been proved.
what is your date of birth? It is 82.
82. 28/1/1982. In this, in some cases, in this novel code, some similar type of matters remain back, given an opportunity to just prove that to particular documents, no other documents, but those particular documents, such as governor certificate. Otherwise, she has no case.
There's the state emblem also. That is also another problem. Now, Prasad. Oh,
So a lawsuit can just on such limited points is went back the matter. Just given opportunity, whether it is correct or not, whether this is genuine or not. Only for that limited purpose. Otherwise, she has no case. And but so far as the voter list
Let him
was-
complete, then we'll hear in details. Don't worry.
No, she can, my lord.
No, you've complete your
Then
arguments.
Only that otherwise voter list are there. Her father voter list is 1965, 70, 1985. All things are there. And she married to one Jabbar Ali, and her name also appeared along with her husband for the first time in the year 1997. So since
Yeah,
she was
gentlemen, you have a seat. You're an intern. Have a seat. There are seats vacant. Seats are vacant. You can have a seat. Don't stand in the. No, not in front. Sit somewhere there in the corner. Do not occupy an advocate's chair, but chairs are vacant, so you can sit.
all these voters list are there.
my lord,
These voters list are there.
there. All voter list were there.
The linkage is to the certificate.
Only while she was a minor, her name necessarily will not
It is not
appear in the voter list with her parents.
What about your voters list?
My voter list there,
Along with your husband?
husband. For
Which
the first time, my name appeared.
Which year?
1997.
97.
Yes, my lord. Page 64. $25, my lord. For the first time, her name appeared. 97.
1997.
Yes, my lord.
Jabbar Ali is your husband?
Husband.
Jagyut.
You will also kindly see the page 60.
60.
60.
Yes, what is there?
It is the voter list of 2005. Related to her father, mother, and all the brothers and sister-in-laws. 60, my lord. Village Sunsiri. And if you also kindly see serial number 154.
Moniruddin is your father?
Father. Zaida Khatun mother.
2005.
Yes. And if you also kindly see serial number 154, Suraj Ali. He is my one of the brother.
It's
And
not 154 is not the serial. 154 is the house number. It is
how
the same.
serial number
Serial is be something A69.
69. Here,
69.
here you will not found
69.
a serial number,
Left side right there.
house number. So some of the Suraj Ali and next Aroj Ali. Both are my brother. And that's Suraj Ali. He witness number 2. He examined as DW2.
Maniruddin
Suraj Ali.
appeared in 1965 list also.
My lord.
Maniruddin appeared in
Yes, yes.
1965 list
Yes,
also.
65, 70 also. 85 also.
No, before the
Yes.
crucial period. 1970 and 66.
And
This was a common reference or what?
my lord.
This reference was against you alone or
And my husband, those are now not there because the tribunal has only proceeded against
You.
petitioner. Because this honorable court passed in judgment that
Sudhir?
yes, so deals
Without there being a specific reference, family members
Yeah.
cannot be proceeded.
Yes. So, my lord, that Suraj Ali has been examined as DW2. He is my brother. And I also mentioned in my written statement about my family. It will also kindly see the written statement. Page 12. Translated copy. Page 12.
But Mr. Ahmed, how do we exercise certiorari jurisdiction? If you had exhibited in accordance with law, then discarded, you have a case for setting aside. Now we have to find fault with the tribunal in rendering the opinion. If we do not find any fault, remand cannot be a matter of routine. Fault is all yours. You did not take steps to prove in
My lord.
accordance with law.
My lord.
Now, if the fault is yours, we are a court of equity. Do we remand? Suppose it was exhibited properly, but still somehow some flaw was noticed by the tribunal and you misappropriation or something or not taken into proper perspective. You make out a case for remand. That is certiorari jurisdiction.
My lord.
Now
It
here, without there being any fault, how do you exercise
But,
that jurisdiction by equity court?
But this matter very sensitive because first right of citizenship has been involved there. In like civil case and other criminal cases, maybe, my lord, it is a very vital question, my lord. So this court can we are going before a court, constitutional court, my lord.
Constitution Court, Court of
My-
Equity, 226.
My lord, 226. Since 226 is there, what power is there? My lord?
White Power Court of Equity. Conduct
Right.
is a very important, and certiorari jurisdiction.
My lord.
The jurisdiction we do not exercise on the drop of a hat. You have to make out a case.
Then,
Yes, anything else, Mr. Ahmed?
then my lord, you'll also kindly see the
Just a minute. Almost like 1 month.
My lord, your lordship is a written statement, page 12. It is a translation copy, my lord. Paragraph 5,
Page 12.
page 12. Paragraph 6, I've given my details. The name of the father and mother of the opposite party, no, one is Moniruddin and Zaida Khatun, respectively. Name of grandfather is Wahid Ali, and name of grandmother is Majaran Bibi. The father of the opposite party number 1, namely Moniruddin, was born at village Haidubi under Ding Swensu, and after 1971, they shifted to village Sonseri. The two villages, namely Haidubi and Sonseri, are adjacent to each other and facing each other in between a road. Father of the opposite party number 1 has no sibling. The opposite party has 7 siblings. It is important. Opposite party number 1 was youngest one. The name of the siblings of opposite party is number 1, Jenatali Surajali, my lord, he was examined. Surajali, Aruzali, he is also my brother. Then we married in 1996, and immediately thereafter her name appeared in the voter list with her husband. Now, also can you see the page 62?
62.
Page 62 is a land document, my lord. Originally, the father of the petition was a land. But subsequently, it has been converted to Medibatta. And since the sisters are given marriage to different places, this two brothers' name has been entered, mutated, my lord, page 62. Because earlier day, my lord, father's land got the.
What is the Montebo?
My lord?
What is the Montebo?
Montebo is there. Medi Corona, Tabato Swensu, Pukun Mote, Pata, Imano, Dagot, Iman Kata, Surojali Namot, or Iman Kata, Imano Namot, Imam Ade Corona. Because it was earlier, it was not a Medi, it was a first land. Thereafter, it has been converted to Medi in the name of two brothers of the petitioners. Originally, his father was occupied that land.
Now, how do you say that father was occupying?
I mentioned in my.
Where?
I mentioned in
No, no.
written statement.
Now, is there any document to show that this
Those data could be not.
that originally this khas land was occupied by your father and it was made Miadi in the names of your brother?
No.
This document Miadi is okay,
Okay.
but this document is of 2013. So, would like to see.
I just want to satisfy the lordship that I am the brother of Surujali. I am the brother of Surujali, and my brother's name appeared along with my father in the voter list. Along with my father. So indirectly, it has been proved that I am the son of Maniruddin, the daughter of Maniruddin. Indirectly proved, my lord. And he also examined as DW2.
Yes.
Now, let's say, if we look into the voter list, all the voter list, my lord, all the voter list is 1965, 1970 has father's name appeared. In 1985, also, his father's name appeared. Then 93 also. Then 79, 1997, page 58 में calibration one.
Page
89, 58.
58.
My lord. 1997 voter list relating to my father, mother, and brother. My father's name, Surajali also appeared and Arajali also appeared in the battle of 1997. And in 1997, my name also appeared along with my husband. Those voter lists were enclosed. And only my submission, my lord, although there is some, your lordship can remand back the matter. And this noble could also in several cases, such type of several cases, they will remand back, only for limited purpose. For,
Yes.
I just now I have not, but I have. I got.
You are depending upon a case which you have not,
No, I'll police my lord, I will police my lord. And
because you know that those would not be followed by this court.
Honorable Justice Buzur Borua and others also demanded back. Because some kaji are not examined, the exhibited documents, the court remand back the matter. Gauhati was not examined. This court hold that only that limited purpose examined and option given to them to cross-examine. In similar, only for that limited purpose, otherwise not. If those
What my
documents,
brother has reminded you that we are not exercising appellate jurisdiction. We are not exercising appellate jurisdiction.
Power, it's all powers. Additional
If
evidence can be
appellate-
taken.
Order 41, order rule 47.
Appellate court
Appellate
can
court
also
can
take
take-
evidence or direct evidence to be taken on a particular point.
but this court is not powerless. Appellate, loss of a citation what happened earlier. Honest tribunal is there is appellate tribunal. They got a chance, but then there are file a application before honorable single bench. Then they get another chance to file before division bench. Now that form was not available there. So definitely this court can exercise jurisdiction.
26 is wide, but certiorari is somewhat,
My lord.
as you
But
know.
tertiary
As you
that does not mean, my lord, that court cannot take a different view. Court can, my lord, this honorable court can take, my lord. So, my lord, moreover, the evidence of DW3 has not taken at all considered. He proved that this is my sister.
DW2.
Yes. He categorically stated she is my sister, younger sister. And so, from an opinion of relationship, that has not been considered by the tribunal. It should be considered. Cannot be discussed. It should be discussed why evidence of DW2 not considered. He specifically stated that she is my sister, and he has there is the supporting document is there that his name appeared along with father, and DW2 as well as the petitioner categorically stated that we are the son of so and so. So definitely linkage is there.
But you know the importance of the significance of oral evidence in absence of, so far as relations is also concerned.
Corroborative.
It can be corroborative, but solitary without any corroboration by documents.
My lord, we are.
The burden to be discharged is on a higher pedestal.
My lord. Now documented proof is there. 65, 70 document is there.
No, that those documents would only prove DW2 is the son of so and so.
My lord.
to prove a relationship of DW2 with the proceeding, there are no documents.
No, document is not there, but specific environment is there.
Will that be enough? That is, will that alone be enough?
My lord,
That definitely will be corroborative.
since this proceeding and the hydraulic case, my lord, this honorable court held that can be considered. Oral evidence cannot be discarded because in civil suit as well as criminal cases, on the basis of oral evidence, person has been acquitted, land decree has been passed on the basis of oral evidence, not documentary evidence
No,
at
no, no,
all.
Mr. Ahmed, you are making a preliminary, elementary fallacy in this. Those are all conducted under the Indian Evidence Act.
My lord.
Here is our proceedings which where the Indian Evidence Act is not there.
Yes.
It's not there.
But
So
hydraulic
you
case,
cannot bring those
my lord,
principles.
but hydraulic case,
The manner of proof, the requirement of proof, the degree of proof, these are all different.
but in the case of hydraulic,
The onus doesn't even, burden doesn't shift on the line.
but in the case of hydraulic, it is specifically accepted. And that judgment that has been not set as
Hyder
a-
Ali has been specifically dealt with in Noor Begum than other cases where there is a requirement of corroboration. It's not that you cannot discard straight away, but we look for corroboration for oral evidence.
My lord.
Because anyone can say and come and say that he is my son, he is my brother, he is my
Yes.
sister. The problem is of such larger magnitude concerning the security integrity of the country that we have to maintain a strict balance.
But yes, but it should be disputed. State should dispute that, yes, I am not the son of. This did not make any dispute. They accepted it. Without any dispute, my lord, the tribunal should not discard it.
Okay, we'll come back after
My-
5 minutes.
my-
You are complete, we'll hear, madam.
my lord.
You be ready for 5 minutes.
Judgment of final, yeah.
You have something more.
No, I know the rest to hydraulic is provided. My lord, my humble fear, my lord, let the matter remain back. This is my humble fear, and this court is not powerless, my lord. This court can do it. Even such as jurisdiction, my lord, this court has the ample power. And regarding, my lord, the proof of relationship, in this case, no document is necessary. Oral evidence is sufficient, my lord, and it is to be considered. And in the case of Sujavali, my lord, 2021 4 GLT.
Sujabali.
Sujavali.
Sujabali.
Sujavali, MD Sujavali, 2021 4 GLT, 664. Paragraph 18, 19, 20 and 21. And this is the judgment rendered after citing the case of Ban Singh and Dol Govinda Pasha. Dujar 2008 4 SCC.
But the origin would be section 50.
50.
Let us read section 50 of the Indian Evidence Act.
15 and 59.
You do not have that Indian Evidence Act. We can lend you one.
No, I think I could look at it for now.
Do you have or you need a copy? We can give you a copy.
Illusive can say I have no.
No, you have a copy. Let us sort out some matters which have unnecessarily
Yes.
taken much time of the courts.
My lord.
Yes.
Yes.
Hmm?
Yes, it is 44.
It is 44. Now it is 44.
No, it doesn't matter.
Madam.
You read 50 of the
Yes.
Evidence Act.
44.
Content.
When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship of any person who, as a member of the family or otherwise, has special means of knowledge on the subject is a relevant fact.
So how does 50 comes in a matter of this nature? What is a relevant fact? When a third party adduces evidence on the relationship of two persons based on the conduct he or she has seen,
No.
then it would be relevant.
Madam.
Why do you need to bring in 50? You are in a much better footing.
Yes.
Yourself, you have come to the witness box and said that he or she is my daughter or father. How is 50 relevant? We are not. See the illustrations.
Indicative or
See the illustrations.
third
and
party.
Yes.
See the illustrations. There are two illustrations.
Yes.
The question is
The
whether
question is
A
whether
and B
A
are
and B were
married.
married. The
Here,
fact that-
A and B both will say they are married or not married. Now, what is relevant? The fact that they were usually received and treated by their friends as husband and wife is relevant. So who will say this?
B also can listen.
See,
The
question
question is whether A was the
married to
legitimate
B.
son of B.
So the fact
The
that A
fact that
was always treated
Always
as such,
treated as such by member of the family
so
is
this
relevant.
evidence is by whom? Neither by A nor by B. It is by third person.
Brother.
When from the conduct, a relationship is made out, that becomes a relevant fact under the Indian
It
Evidence
may
Act.
be a family member or otherwise.
Yes.
That's what the section
Here,
says.
see, Mr. Your oral evidence that he or she is your son, that itself is a different relevant fact. You need not bring in all the
That is direct-
records of 50.
Direct.
You do not know why 50 are in
Then
discussed and unnecessary.
Those facts has been considered in the case of hydroelement.
See, hydrorally itself would stand in a different footing. If a person comes to the witness
civil-
box and asserts that he or she is my son or father or daughter, that itself is a relevant fact. How much that will be admissible, that's a different matter. We are only on the relevancy of fact. 50 is on the conduct. From the conduct, if some relationship is justified, then it will become a relevant fact.
So
And
otherwise,
evidence is given on the basis
otherwise
of
I
that
have,
conduct.
otherwise
About
I have,
first conduct.
I have no, only my prayer is on that two grounds. Given opportunity to remand back the matters. And I will place two orders. Just I asking, I will continue that this honorable court remand back similar nature matter remanded back. I will put this one.
To prove the school certificate. This,
Gabra certificate, some cases,
no, this case, you want to prove.
Gabra and school certificate.
Do both.
Others my friend would like to place is, I remember those cases where those documents were not even mentioned in the opinion, neither appreciated nor examined. He would be placing those documents, orders lordship. May I now take lordship to the opinion lordship. Lordship, the voters list, first I would like to start with the voters list. 65, 70, 85 and 93 is a single name voter list only of the father.
Just a minute. You said that where some documents are not at all considered,
Yes.
a case for remand may be made out.
Yes, though it was there, some courts, some.
Adduced in evidence but not
It was-
considered.
They had placed it, it was not
then
appreciated, not
eliminate.
examined. So those matters were remanded back.
But not in this case.
But in this case.
It was not proved.
No, not only.
Not
it was-
adduced in evidence.
It has been mentioned in the opinion. It has been taken into consideration and then that opinion has
Adduced in
been
evidence
passed.
but not proved properly.
I'll take lordship to the opinion also, lordship.
Page.
Lordship, page 49 is the 65 voter list. 65 voter list, lordship. Father's name is Demani Rudit. Then Lordship will turn to page 51,
You're at page 49.
49.
Let us come to
Typed
the,
copy, Lordship.
we'll come to 50. We'll see the vernacular 50 is the 1965 voter list, Moniruddin.
Single name voter list, Lordship, no brothers, no siblings, no family, nothing. Then 51, again page 51, 90, voters list of 1970. The village and the Gao village and the Moza continues to be the same, Lordship. Then Lordship will come to page 53, 1985 voters list. From 65 to 70, 70 to 85, 15 years of no explanation, Lordship, whether they have been residing here or they have not been residing here. 85 is again a single voter list at page 53, Lordship. The village and the division remains the same. And the father is 70 years now, Lordship. In 85, father is 70 years, but the family members' names are not there in the voters list. He has 2 sons, 3 daughters, and a wife, Lordship. Then from 85, the next voters list.
Just a minute, please. Just. And just a minute. Ding down. Oh, here. Discrepancy in the age. In case 57. This is 1965. 1965. Page 50.
Yes. I mentioned here, well, in written statement, my lord. Yes. Yes. My lord. Haidobi, original Haidobi, then there, my lord. Yes. $70 years. 1970 years. No, we mentioned in the written statement. My lord, paragraph 6, page 13. 13. The father of the opposite pattern one, namely Moniruddin, was born at village Haidubi under Ding police station, and after 71 and this shift 71, he shifted to Swansea. Yes. My age regards so far, but so far as age is concerned, there is a this honorable court passed several judgments regarding as mentioned in the voter list. Yeah. Yes. My lord. 85. My lord. Yes.
65.
My
Yes,
lord.
that is it.
My lord. But you lost locality. Page in my lord. After 71. My lord. My lord. My lord. So so far as age is concerned, I just give you page 53, 85 voter list, 70 years. Then in 1993, 80 years. My lord.
After 85, it is. Exactly.
So far as age factor is concerned, no, it is wrong. It is wrong in the mention voter list.
Is
My
the
lord.
70 onwards is the correct age, then
Yeah.
the first two ages are incorrect, 65 and 70.
Link lordship. That is
My
what
lord,
I-
Because there's a gap of
My lord,
25 years.
Right, 70 made 50 or something, then you just said,
my lord.
by some flaw, it becomes 70,
My
and
lord.
it's corrected. Now the 70 has been consistent. After 70, it gradually increases. This monument of 85 is having a voter list. Now, if you want to show that this monument and the 65 and 70 monument are the same person, then. And if 55, 70 goes, 85 voter list will say nothing.
One example I given in lordships, kindly see. Page 56, 85 voter, 83, 85, 93 voter list, my lord. Kindly see. 93 voter list, his father is recorded as 80.
Yes.
80, 85, 70.
Should have been
Let's look at
78.
list. Then in 1997 voter list, also 80. Those things are happen.
This is a
Again 80, my lord.
same.
Suppose these are not same persons. Then suppose voter list person Moniruddin appear in the voter 93 and Moniruddin appear in the 97. It's same person. Then also
84.
Different is 4 years.
84.
4 years.
It should have been 80, it should have been 84, it has not been 84.
Hmm.
But how can 30 become 70?
And it becomes 90. This is again maintained.
30, 85. It should be
25 years difference.
45, 45, 50. It is happen, my lord. In voter list, so far as there is voter list, age may not be, my lord.
My age,
My lord.
they may make mistake, 1 year, 3 years, 3 years, 4 years, 5 years, 25 years.
In this regard also,
That is a change of
my
address.
lord, in this, my lord, in this regard also, our honorable court, in one judgment held that those are not factor, because sometimes 10 years increasing and next year 20 years decreasing, not a matter. Taliban Rahman case, my lord.
It's discrepancy.
My lord. My lord. So otherwise, we cannot develop it. My lord. Only, my lord. But only my submission, these 2 points, it may be remanded. Only the 2 point. I will place those judgment, my lord, remand that I am searching, my lord, I will give you.
Lordship, may I continue?
Answer.
And these discussions we are making only on the aspect that you are paying for a demand rules.
These two,
Those two.
those two.
So we are trying to get ourselves satisfied that the other methods are such that you may have a case for it.
Right.
This was that one.
Right.
Otherwise, these documents are not the proof of your connection.
My lord.
Lordship, after the voters list, I would like to draw Lordship's attention to my friend had said that the transfer certificate and the Gauhati certificate has not been appreciated or examined by the tribunal. May I draw Lordship's attention to first to the transfer certificate,
No,
Lordship?
I mean, it not sense. Yesterday I could not prove it. So give me a chance to prove.
No, I said it is not proved, Lordship. He said it is there, I said it is not proved, so it's not.
Yes, sir, frank. That
Yes.
has not been proved according to the person did not come.
No, did not come, so I will just say, take Lordship, because it is, he is praying for a remand
Yes.
on the grounds that the document has not been examined or not been proved. So it has already been discussed at page 42, Lordship. Page 41, last paragraph of the opinion, Lordship. Paragraph 8. The OP Suleiman Khatun has relied on the school transfer certificate as Exhibit A, issued by the headmaster secretary of so and so.
Page 41.
Page 41, paragraph 8. Issued by the headmaster secretary of Soneshwari ME Vidyapit, which was again countersigned by Block Elementary Education Officer on 17/4/18 as a linkage with her father. Now it is to observe here that the document contended her date of school leaving as 31/12/1992, but it was issued much belatedly on 17/4/2018 by the issuing authority. Such belated issuance of the document cannot be relied by the court. That apart the said document, which amounts to a private document under section 75 of the Evidence Act, needs to be proved before the court by testifying the issuing authority in accordance with law. Since the OP could not substantiate the genuinity of the document as well as the truthfulness of its contents by proving it before the court, they said exhibit does not have any probative value. So, and Lordship, the Gauhati certificate has also been examined at paragraph 9. And it is not that he prayed to bring his witnesses. He did not pray, because if he had prayed, there would have been some mention about it. The most important and two relevant document which would have helped him, Lordship, is the transfer certificate and the Gauhati certificate. Both have not been proved. And Gauhati certificate has a state emblem, so otherwise also it would not have been relevant, Lordship. Then DW2.
That we have some reservation. That is an unauthorized use of state emblem.
Yes,
That
sir.
itself should not make the entire contents validity. We still examine if the contents are in his favor. Yes, use of state emblem may lead to some other consequences. He could not have done. But can the content be nullified? Perhaps not.
Then we'll have to go back to Rupajan. It has, the contents has to be,
Not Gopal.
it's
Rupjan,
Lordship, it's
Baban.
Rupajan, Lordship.
The paragraph 9.
No, that is written wrongly, Lordship. It is otherwise it's Rupajan. So these two, if these two documents go, then the deposition of DW2, which he has submitted had not been considered, Lordship. I
So
think
paragraph 8 and 9 are the discussions on this course certificate.
in the Gauhati certificate, then lordship deposition of DW2 at page 34. Page, may I read it, lordship? My name is Suruj Ali, son of Maniruddin.
34.
Yes, lordship.
Where is it? 36.
34.
34 is the verdict.
Yes, I'm reading.
Doesn't matter, very fast.
Yes. I'm reading the English version, lordship. My name is Suruj Ali, son of so and so, aged about 58 years, resident of Sunseri under PS Dihing, district Nagaon. I have appeared before the court as a witness in the instance reference case against my sister, Sulema Khatun. My sister is about 37 years old, but I don't know her birth date. I am illiterate person. I also born and brought up in Haidubi under Dihing PS. My sister Suleiman Khatun was born in Sunseri. We have 3 brothers and 3 sisters, namely so and so. My other brother and sisters were all born in Haidubi, except my younger sister, Suleiman. I don't know which year my father shifted.
This is the cross done.
Yes. In his cross lordship, he says, yes, my
This 34 is the chief in verdict.
yes, lordship.
36 is the cross examination.
I'm reading 34, lordship.
34 is the examination in chief.
Yes.
Pages there some.
Yes, maybe, lordship.
No,
So-
36 is the cross examination.
Brother says,
Oh. Oh. Oh.
What is there in cross? Which part?
3 brothers.
lordship, the whole cross is important because it will, I will take lordship to the opinion back again.
We are still sisters.
Yes. And my other brothers and sisters were all born in Haidubi, except my younger sister, Suleiman Khatun. I don't know which year my father shifted to Sunseri along with his family. My father died in 2005. I have heard from villagers that at the time of his death, he was about 100 years old. My mother is Joyda Khatun. She expired on after 2-3 years after father's death. At the time of mother's death, she was 80 years old. We have casted vote in Sunseri with father and mother. My father had casted vote in Haidubi also. I don't know since when I casted vote, but I'm regularly casting vote now at Sunseri. My sister, Sulema Khatun, presently stays in Mati Parbat. She's married to so-and-so. I don't know the year of her marriage. She studied in primary school at village Sunseri. She has obtained school certificate belatedly to produce it before the court in her reference case. I don't know who is Saidur Hussain, who has issued a residential certificate as linkage to my sister, but I think he's the Gauhati of Sunseri village and adjacent village. The land where we are residing by constructing a house is in the name of my younger brother and myself. Whatever I have deposed before the court is true to my knowledge and belief. Now, lordship may come to page 41, lordship. How the tribunal has dealt with the deposition and cross of the DW, lordship. First, first paragraph, lordship. Subsequently, this court proceeded to examine DW2, Suruj Ali, whom the OP claimed to be her brother and adduced him as oral evidence in her case. The said witness submitted that his sister, OP Suleiman Khatun, is 37 years old and their father died in 2005 at the age of 100 years. The mother died some 2-3 years later to his father's death at the age of 80 years. If the testimony of the DW2 is to be believed by the court, it is apparent that OP Suleiman's father gave birth to her at the age of 77 years or so, based on her present age and birth year 1982. On the other hand, her mother's age at that time of her birth could be somewhere around 53 years or so. This absurd fact explained by the DW2 cannot be taken into account as it is wholly unreliable and illogical, seeing the age of the parents. However, it will be pertinent to mention here that medical science considers age 35 as an advanced maternal age of a woman and 40 years as an advanced paternal age of a man. Although it may vary person to person, it cannot exceed beyond a reasonable age in both in man and woman. According to medical science, childbearing capacity of a woman cannot exceed the age of 51 years, since it is treated to be the average age of menopause. Decline in fertility begins to accelerate in women after 50 years. Similarly, paternal age of a man cannot exceed 70 years, since reproductive capacity in man declines in such advanced age. Hence, it is prima facie evident that Moniruddin and Jayeda Khatun cannot be the biological parents of the OP Sulema Khatun. Moreover, the DW2 stated that there are 6 brothers and sisters and all the sons and daughters were born at village Haidubi, except the OP Sulema Khatun who was born at village Soncheri. On the contrary, the OP deposed that there were 7 brothers and sisters but did not disclose the birthplace of her brothers and sisters. So the statement of the DW2 regarding the place of birth of the OP in Soncheri and other siblings at Haidubi seems to be doubtful. It is presumed that the DW2 deposed as such just to link his relationship with the OP, Sulema Khatun, with the intent to place Moniruddin as the father of the OP. Moreover, the OP said her father shifted to Sunseri after 1970, whereas DW2 deposed that he had no idea when his father shifted to Sunseri. However, there is no evidence that Moniruddin shifted to Sunseri and gave birth to the OP in the said village in 1982. It also seems to be illogical and doubtful while the DW2 goes to claim that the only OP, Sulema Khatun, was given education till class 5 in Soncheri among all the brothers and sisters by their father. It is presumed that the DW2 would have taken such plea so as to produce a belated school certificate to suit their purpose. That apart, DW2 did not disclose any grandparent's name in the lineage. After testifying both the witnesses, it leads to the presumption that the OP and DW2 are not siblings born out of the same father. It has been very elaborately examined, researched, and this opinion has been passed, Lordship. And so far as the matter for remand comes, Lordship, these documents have been examined, have been taken into consideration, and it finds its place in the opinion. It is not that it has been completely discarded, not looked into, not mentioned. My submission is that the OP, that the petitioner has failed to make out a case of a linkage with the projected parents and brothers, and the tribunal's opinion is not to be interfered with, Lordship.
Okay.
Your Honor.
My lord. No, it is correct, my lord, judgment, but if lordship, I got one order of this noble code, WBC number 3651/2016. 3651/2016. Name Rahela Bibi. Order dated 6/3/2019. Yes. I give you. Other several judgment are there. At present, I have no copy. But I will give the 9. I mark it.
9.
Right, yes. Without expressing the.
Here there is no precedent as such. If we can read it out, so without expressing any view of the merit of the contention, this is the constitutions. We also view that facts and circumstances of the present case. Interest of justice will be met if the petitioner is allowed to examine the person certifying the government has certificate in order to authenticate the same certificate as well as to prove the content thereof. As the certificate was issued by the president of the government chair, we deem it more appropriate if the secretary of the government chair examined it as much as the secretary is an officer under the. We can express.
Other some, I will press
On
that.
facts.
Other orders are there regarding
Chief, I would still submit that these documents have been considered, Lordship. It will be an endless exercise if matters keep on going back on already. If the documents have been examined, Lordship. 2019 and that certificate is, she was born in 82. She had sufficient time before the tribunal to ask to have a witness examined, Lordship. It is not that she was denied. The records does not say she even asked for the witnesses to come. Lordship, we cannot keep on sending it back for endless.
Was in the context of the review and all. Do you have any shift? Because even on remand, it cannot be an endless exercise. We have come across decisions
Yes,
where.
sufficient opportunity granted and endless. No, Lordship, here also, my submission is, had it not been part of the opinion, those two certificates, it is not that the tribunal did not look into, tribunal looked into it very well.
Touched upon it. Yeah.
And has then passed the opinion, Lordship. Again, sending it back, Lordship, I do not think that it would be a very good idea to send it back again, Lordship. If once we start doing this,
Mr. Your friend.
the Lordship has to decide it. If Lordship,
This is a very good.
no, Lordship, what I have more to submit, if Lordship in this matter remands it back, then this judgment will keep on coming back and we cannot deny that no, if one matter has gone back, the others should also go back. We cannot let it continue year after year, Lordship.
only practice matter we could not examine.
They had enough,
This is that.
Lordship. It is not that they did not have
But-
time. Lordship will see when the proceedings started. The records are
other-
there, Lordship.
Otherwise, the judgment also, if also can see the already gone through the judgments. I think London member is a very good doctor. Good doctor, scientist, my lord. He cannot make such an observation, my lord. How can he paternity, fertility, how can he is a doctor, my lord? He
Lordship will
cannot
see
make a
that
such
this is a
comment in the
identity
judgment, my
that-
lord.
Lordship,
He is
this-
not a doctor, he is not a physician.
this
He
is
just give opinion on the basis of documents. Whether it is possible, a person 73 years cannot give birth to a child. Possible.
77 years giving birth.
70 years possible, my lord.
77.
Possible. Now it possible. Possible. If a lady is 50 years, 45, 53 years,
That is
then
unlikely.
possible.
That is unlikely.
Possible, my lord.
Women unlikely.
That tribunal member cannot discuss such type of observation. Cannot make.
tribunal cannot do many things, but the
77.
petitions bring in everything, Lordship.
53 is unlikely.
My
Unlikely
lord.
for a woman.
It's a IMDT reference of 2002, Lordship.
He will be an inspiration for many.
Many example is there in our village.
Is it?
Yes, madam.
Well,
Many example, madam. Yes. But so tribunal should be restrained making such type of observation, my lord.
Rejected far.
May he declared, it is correct, I could not produce my case, he's enough to declare me as foreigner, so but he cannot make such observations.
The documents made him do that.
No, no, document, I will foreigners, documents say I am foreigners. My lord.
You went there,
So,
you
my
went
lord,
in medical, and court can, law has many facets, right? It's about,
And to justify his rejection, he has done it in a very proper manner.
Serious, this discussion doesn't appear to be irrelevant.
My lord,
He
really,
has to be conscious to the facts.
my lord.
He has to answer this reference. The discussion which is, maybe he has gone a bit more on the scientific aspect,
Yes, my lord.
but this you cannot speak or irrelevant, very much relevant.
for the woman, yes. It is not completely off the point, of the mark. Let me see.
My lord. If I got, I'll do judgment regarding demand back order, my lord. If I got.
The return on judgments. We have to be even time to write it.
My lord, my lord. I love it.
No, to them. एक नंबर तो एक नंबर टाइम नहीं आसे और करो भाई 41 is also 41 is also 19 41
Lordship, yet two lordship. Or like put number 15 lordship. A is Yamar Chaudhary lordship. Will argue the case is 15 lordship.
41 Item number 1.
May I please?
What is it?
Input order, my lord, page number 51. He has been declared as a foreigner, my lord. After 25/3/71 instrument. Order dated, my lord, 12/6/2019.
What we are paying, madam, what we are paying.
Lordship, it will be completed by Mr. Sharma at two, Lordship. Because I will not be. Lordship may record G Sharma's name, I will be assisting.
The courts. Timings for you is different.
Lordship, I have another matter in the family court, Lordship, I have to.
You're not seeing in the second half. Would be a presentation.
Mr. Sharma, Lordship, please Lordship may record Mr. Sharma's.
Your fault? Yeah. Stapler.
Date of the opinion, my lord, 12,
Uh,
12/6/2019. Page number 51.
That would you.
51. FT number 6, Borpeta. Lordship.
What is your date of birth? Date of birth, year of birth,
My lord,
or date of birth?
As per the affidavit, it would be 1977,
Lordship.
2019. No.
77.
Lordship.
Let's find the. How many evidence did you do?
3.
4.
4 numbers.
4.
Who are those?
The petitioner himself, his father,
One is petitioner.
petitioner. DW2 is the father.
Father.
And she is the Gavura,
Four.
and 4 is the secretary of Panchayat.
Secretary of?
Panchayat, Gau Panchayat.
No, contact the secretary.
Lordship.
Secretary government care. Yes, what are your?
During trial, my lord,
Statement?
written statement, my lord. Is number 31. Very short written statement has been submitted, my lord. Page number 31 is the written statement.
Yes. Date of filing. That's 7/17.
10/7/17. The written statement, my lord, not elaborately discuss everything, my lord. Nothing, my lord. During trial, my lord. Lordship. But
What is your father's name?
Lordship. In 66 voter list, my lord. Repeat.
For your parents, your siblings, grandfather, grandmother.
My lord, in page number 32 only stated that in 1966 and 70, grandfather of the second party, namely Afsar Khan, was in voter in 1966 and 70. And in paragraph number 7, his father's name.
Maybe at 210 will sit. I think statement is a bit brief.
May please, Lordship, Lordship.
Yes.
May please, Lordship.
It's here in Assam. It's here for Assam. The forensic book is V9. The forensic is V9. Okay. Is number in Marco somehow? It's 24.
What's next?
Now, my lord, my lord, the DW2 is the father, my lord. Lordship. So, my lord, the evidence of
Four
father,
is the
Lordship.
Secretary Government Chair.
So evidence of father will be vital, my lord, because he knows everything regarding his daughter.
Hmm.
And deposition of the father, my lord, that page 38,
3-8.
Lordship. Now, written statement, evidence, my lord, drafted so casually, my lord. And we have instruction that against this advocate, several complaints was filed before the Bar Council.
Where is your statement?
That statement, my lord.
So the advocate of the tribunal, not only the
He
tribunal, advocate,
produced all documents, my lord, did not narrate anything.
no, the advocate of the tribunal, not only the tribunal, even the advocate of the High Court is negligent.
Lord, because
You have not stated that you have taken steps against the advocate in your pleadings in the High Court. In the writ petition, where is that statement?
that was not there.
So-
We have not filed any complaint.
So negligence is both yours.
We have
Why are you
not-
blaming the advocate in the district court?
Because complaint was filed before the Bar Council.
Where is the pleadings? Have you stated?
No. And from the evidence, my lord, that the parties, my lord, furnished all documents. It was not narrated in any manner, just exhibited. Now, in case of citizenship, my lord, lordship, my lord.
No, you are showing us page 38, DW2.
Lordship.
What is there in DW2?
Paragraph 2, my lord.
Hmm.
Second party, opposite party of this above noted case is my daughter. The second party was born and brought up at village so and so. Mauza Mondia, PS Bagbo, district Borbita. After gaining measure, she was given in marriage to Ainal Haq
son of so-and-so, village Shotrapanara, Ondia, PS Bagbo, district Borpeta. Where my father, namely Afsar Khan, was voter of 1986, 1966, 1970, 1985, quite serial number so-and-so of village Sasra under Bagbo LS. I am also voter in the voter list of 1985, 99, 2010, 2014, quite serial number so-and-so. Now, in this case, my lord, the case initiated on the basis of reference, my lord, it is in the page number 24 in the TCR, my lord. '24, '25, '26, and '27. Lordship,
You do not know the date of,
date
maybe,
of birth
maybe you do not know date and year of birth of your
My lord.
daughter.
in the cross part, my lord.
That is very sincere. Page 40.
Page 40 cross part.
Okay, rustic villager date you might forget, but the
Well,
year.
also, my lord, if my lord, year, remember, that was also on presumption 40 years back.
No, year of birth.
So maybe 40 years back.
Hmm.
And there is no reference against the father, my lord. Father had no reference.
Hmm?
There is no case pending or was initiated against the father.
How is that relevant?
Relevancy, my lord, that father is a citizen of India, my lord.
That has to be a projected father. You have to prove that he's your father. That is what we are seeking.
Once that is proved, then it will automatically.
That is the point where the entire discussion is about. Somebody claims to be his daughter. Just be proved in accordance with law. Prove the link, get out of it.
Best person is the father, my lord. In this case, Gaubura has also examined, my
Let
lord.
us see the documents.
Documents, my lord. And one thing you lordship may kindly note, my lord, the reference, my lord. The reference is also entirely blank.
The
There is-
reference, LVO report, those
even-
will not make any difference. You come, show us the documents. Documents,
Lord,
written statement, deposition, cross-examination.
page 16, my lord,
1-6.
1-6. The grandfather, my lord.
Grandfather is Afsar Khan.
Lordship. Grandmother Maziran and Haziran.
Upstairs. Upstairs is your grandfather.
Lordship. Afsar Khan. Afsar Khan. In 70 also, my lord, same. Is it
Who are Maziran?
grandmother, my lord.
Maziran. And Hazira?
She is also grandmother.
Page 18, my lord, 1970, same, my lord.
1970, 65, 66. 1970. 66. Nineteen 85.
Seventy we have seen, thereafter
Then 85, page-
grandfather and grandmother.
lost it. Then 85, my lord.
85.
85. Page 20, page 20, relevant page 21.
Eighty-five,
Page 21.
who's there?
Grandfather, grandmother, and father. But in the Lordship, kindly note, my lord, the name of father and husband column, my lord.
Voters list is up to 2014.
Plus.
Father.
2014.
Sona Panis.
Some certificate to be.
Who is Sultan Khan?
Father, my.
Father.
Father. And the difference of age between your father and mother?
Shown 10 years.
Hmm?
It has been shown as 10 years.
Biological mother. Biological mother.
Lost.
You see as a stepfather, stepmother also.
No, no. See, your grandmother is 50 years and one is 40 years. Let us give you the benefit that the 150 years is your grandmother.
No,
Then your-
yes, my lord.
And your father is 40 years, only
40.
10 years difference.
Now, this is prepared by the election commission. And here, my lord, in the father's column, my lord, grandfather's name has been shown as
Yes, he's your
great
father.
grandfather's name has been shown, my lord.
Huh? He's your father, Sultan. Sultan Khan's father is Afsar.
Afsar Khan, my lord,
Afsar.
son of Mofez.
Uh-huh.
Then Moziran, my lord, again Mofez.
Yes.
Then my lord, Hazira, again Mofez. It should be Afsar, my lord. In the 670 document, my lord, lordship seen, my lord.
But we are gonna expect that Sultan Khan,
Sultan is the lordship.
which is
So-
your father,
So,
he is 40 years, where your grandmother is 50 years. Please, 21. 21.
85.
21, 85. Afsar Khan is the grandfather. Moziran is the grandmother. And father Sultan Khan, see the difference between Sultan and Moziran, 10 years. And if you take Hazira to be Khatun, Hazira Khatun to be your grandmother, there's no difference between your father and the
This is a disputed. Cannot be
97 and 50.
10 years. No.
Also minus 1.
30.
Yes.
60 to this edge, go the drop way. Yes, gosh. One number, look, right? 70.
Yes.
Then voter list of 97, my lord, page 22, my lord.
Who are there?
Here also, my lord, father, serial number 100. Then mother 101. Then uncle,
Mother is
lost.
Sabzan.
Lost.
Sabzan.
Ninety. 96.
Hanif, who is Hanif?
Yeah. Hanif is uncle, my lord. After. Samal, right? Yeah.
Brother of Sultan. Hanif. Afsar.
What word is after Hanif? Who are this?
Hanif, my lord.
Hanif is your brother?
Yes, my lord.
No.
Uncle of the petitioner.
Uncle and
Brother of Sultan.
Brother of Sultan.
and thereafter what is there?
Jamal Khan
No,
is the
above
brother.
Jamal?
Jamal is the brother.
Above Jamal?
Falani Nessa is aunt mine. What is the name?
Jamal is your brother?
Lost.
Okay. Where are you? 97. You were born in 77. If you were 97, your name should have been there.
She was married in the year 1995. She got married.
So where is your name?
So, my lord, her name was not with the family members, my lord.
Then your name
And
is,
from 97, my lord, she is the voter.
so there is no
No.
voter list of yours, single. See, you were born in 77. How do you connect your name with the projected parents or brother? Which is the document?
There is no document as such, my lord. Only statement of the father. Then, my lord, certificate issued by the Gau Panchayat and Gaubura, my lord. Gaubura is also leading person of the
He has adduced evidence.
Bosch. Now, father had landed properties, my lord. Father already expired. Mutation of the one now. She did not go to school, therefore there is no certificate also. Okay. Over 72 years. Now, deposition of Gaura, my lord, is 43, my lord. He was at that time 72 years.
Page?
Page 43.
Please read.
Hello. I am the Gaura of village Aligaon. I am also in charge of village Shastra for last 2 years. I know Opi Sunabhanu. Her father's name is Sultan Khan. I know Opi is married with one Ainal Haq, son of so-and-so of Satragonara, Govindapur Reserve. Exhibit G is issued by me on behalf of Sunabhanu. Exhibit G1 is my signature. I have issued the said documents on the request of OP and her father. I know OP, her father, for many years. I also know his family members, and on that knowledge, I have issued Exhibit G. I know OP's parents' name and other family members' name are enrolled in the voter list. I am maintaining a register book for the purpose of village survey as per initiation of issued by the Circle Officer, Bagbor Revenue Circle. Exhibit G2 is the relevant page where Circle Officer had certified with the seal and signature. Exhibit G3 is the relevant page of said register book. Exhibit G4 is my identity. In passport, my lord, I certified that OP is a resident of village Sasra. I have not mentioned about OP's father's inhabitants in Village Sastra, I have checked and verified Sultan Khan's name in the voter list, but I had not mentioned about voter list. Maybe Shunabanu is about 40 years old now. I do not know when she was born. I do not know her date of marriage. Maybe about 38 years ago. I remember about the year 1980, she might had got married. I had not attended her marriage. I do not know at what age she got married. The house number entry in Exhibit Z3 as house number 36, serial number 180 is made 2 years back. Since I was holding the post of Gavura of Village Sastra as in charge for last 2 years. Only, and I do not know what was the family of Sultan Khan 2 years back. Exhibit Z3 only established the fact that Sultan Khan is resident of Village Sastra, but it does not reflect for how long he is residing in Village Sastra. He may be about 70 years old now. I have seen him since my childhood. When I went the Village Sastra from Aligaon towards Mondia onto Sadar Barbeta, then I used to see Sultan Khan and his family. It is not a fact that I do not know Sultan Khan and his daughter Sunabanu. It is not a fact that Sunabanu's parents was not resident of village so-and-so. It is not a fact that her parents are in Indian. It is not a fact that without record I have issued the certificate. So he was my lord Gavura. He was leading person of the village, my lord, 72 years. And population registration register book, my lord. It is also available in the TCR, my lord.
Sorry, please.
Lost.
This is what is stated in the cross-examination.
Certificate for now. Certificate. It's 29. Pravesh. Pravesh na? Pravesh na. Now, certificate, my lord, that exhibit Z, my lord, page 29. Lost. Lost it.
Let us see page 30. 30 is the
30. Lost. Page 30 particular, my lord. Sunabanu Peter Sultan Khan, village Sasra.
What is the date of this certificate?
Date, my lord, 6/6/17, my lord, 6/6/2017.
Hmm.
And he was examined, my lord, on 17/8/2018.
On the basis of information register.
And
It was issued on the-
and population registration, my lord, that was also exhibited, my lord.
What is this certificate, Gampura?
That he is the proceed is the son, daughter of so and so, and
That is.
Lord.
And
And her marriage was solemnized.
Sona Bhanu, Peter Sultan Khan.
And regarding others,
It's not a birth certificate, it's a residential certificate. The certification is only on the part that she is residing. ইয়াৰ দ্বাৰা প্ৰমাণ পত্ৰ দিয়া হ'ল যে so-and-so, পিতা so-and-so, খান so-and-so, ডাকঘৰ so-and-so, মন্দিয়া, থানা, বাগবৰৰ, বৰপেটাৰ, অসম। উক্ত মানুহজনী মোৰ নম্বৰ so-and-so তাৰিখে চাচৰা গাঁৱত বাসিন্দা হয়। ৰেচিডেন্সিপ চাৰ্টিফিকেট।
And her marriage was solemnized, my lord, and that was also. And regarding fathers, my lord, population registration was also exhibited, that was in the TCR, my lord. It was produced by the Gauhati. Exhibit Z3, Z Roman 3. Page 59 and 60 of the TCR.
Page
59 and 60 of the TCR.
This DW3 is the same person. Forest, no, Prohibitions.
Sarvesh.
Is it Sarvesh?
Sarvesh, madam.
Sarvesh? Sarvesh Ali.
Sarvesh Ali. Sarvesh Ali.
Yes.
Another link, PW4 is the secretary, my lord. Secretary certificate, CPG 28. Thank you, yes.
Yes.
Now, page 28, my lord, the certificate issued by my lord Gaupon sir. And it was accepted as linkage certificate during my lord NRC process.
Disclaimer.
Last, as per our Supreme Court.
Disclaimer. footnote.
Page 20. It was also proved by examining the secretary.
About shifting.
Page 28. Page 28 is the certificate and
The adduced evidences,
DW 4, 4, page 49. There are the there. Sure. Huh? It was countersigned by the block development officer.
How did he issue this certificate?
This is regarding linkage of
Now, what is the basis? What did he state in his deposition? DW4?
or DW formula after verification of her father's document. Father grandfather's document, my lord.
Now, how did he know that she is the daughter?
She is from same village, my lord.
Who? Let us see Panchayat, this Panchayat.
Panchayat, my lord, Panchayat secretary.
Yes.
Sosra.
Page?
Page, my lord, from same Gaon Panchayat, my lord. Page 49. He is the secretary of Gaon Panchayat, Saprakonora Gaon Panchayat.
I do not know Sona Bhanu personally.
And regarding her father's identity, he
knows the father. Father's citizenship is not the question before us.
So
I
this
do
is
not know personally.
But has he stated that he knows her as the daughter of Sultan? Has he stated?
See, if with this certificate admittedly is on the basis of the documents, voter list of 66, 70, 97 and the NRC, probably certificate will not be able to stand. Because those will not create a link of the father and the daughter. 66, daughter is not
No.
there.
Daughter is not there, even father was also not in the 66. Grandfather is there.
So it's mainly on the basis of a
Others.
I don't know, so and so, her father is so and so, married to. I had issued certificate in my signature. No name. As a part of the documents, OP had submitted an application along with NRC details. Next please. I came to know OP Sona Bhanu only after she applied for the certificate. That means he doesn't have any personal knowledge at all regarding the relationship. So this was the case, perhaps 50 could have been invoked, but under 50 of the Evidence Act. But under this facts and circumstances, 50 will not come. They are not seen the conduct of the parties as relations, as relatives.
NRC details paragraph. Exhibit NRC paragraph.
I do not know her husband also.
Exhibit provision.
Whatever she had entered in her application, I have mentioned in the certificate. Towards the last.
Did not know her before.
Hmm. 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 Hmm.
How is this discussed by the learned tribunal?
Exhibit. Exhibit program. Exhibit below. Relevant. Example 4. Page 56, my lord, paragraph 10. Mainly on the ground of he had no personal knowledge. That is the main.
Wait, para 10.
Lordship. Page 56, para 10. Nine. Nine. Nine is regarding DW3, DW2 and 3.
Yes. Yes, anything else?
No. And discussion regarding father, my lord, page, paragraph 11.
Hmm?
Paragraph 11, my lord,
11.
Page 57.
13.
11, 12, and 13.
So it was held that the linkage with Afsar Khan
Yes.
could not be built. Because his name had appeared in
Yes, madam.
1966 in 70 voters list.
So linkage, my lord, the father's statement and documents, and then my lord, Gaura's certificate. Gaura's certificate is not, my lord, is proof, my lord, that she is the daughter of Sultan Khan.
See, you, as linkage, you have the father deposing.
Lord.
And as for documents, there are two certificates
One certificate regarding secretary, my lord.
and one by the Panchayat. Panchayat, one by the Gampura.
Gaupura. So even if lordship, my lord, Panchayat secretary has no knowledge, personal knowledge, my lord. And the Gaupura, my lord, she knows the entire family, my lord. In her statement, it was not discarded also. And he was 72 years at that time. And regarding document of the petitioner, my lord, she has no
Let us see the,
Document.
where is GW3 again? Page?
page 43, my lord. I know opposite party, so and so, her father's name, so and so, I know. And she knows her family also. I know his parents' name and other.
Just a minute, just a minute.
Lord. Then. Certificate plus deposition process.
Yes.
Now, regarding, my lord, the age discrepancy of father, my lord, your lordship knows, my lord, the how, my lord, election commission, my lord, or they prepared voter list.
No,
Not
we
a-
are trying to have a
lost.
link with your.
Even, my lord, till today, my lord, although, my lord, technology has been developed, even, my lord, till today, there is everyday correction is there. And the Honorable Supreme Court in Rohimali's case has, my lord, observed that a fake document, my lord, or genuine document. Genuine document, my lord, always placed casually. Because fake document is placed carefully.
We have to continue tomorrow,
Sure.
Mr. We have to continue tomorrow. Today there is some meeting I have to rise and the other is a single bench. We have to sit in a single bench for 2 minutes. Tomorrow we'll continue, huh? You have completed first hearing matter. Hearing means disposal matter. A final consideration matter. Heard in parts, listing in tomorrow. Report. এটা বলে ক্রেডিট খালি বানাবো মোট সিঙ্গেল বেস এটি যদি হয় 5 মিনিট এটি তিনটা দহত বহি তিনটা পাস এটা লাগিলে এটা না ভাই সিম্পল this matter was fixed today
Yes, sir.
on the submissions that the
Your Honor, senior is on his way.
that the matter before the learned DRT number 2 Kolkata was fixed on 23/7/2026. This court has however been informed that on 23/7/2026, when the matter was taken up, the same has been adjourned and fixed on 25/8/2026. Full stop. In view of the above, consideration of this matter is deferred to be listed on on 15th of September. 15th September.